I had this thought that we seldom have the chance to see what it is like for a CEO to talk with a lawyer, like the CEO's lawyer. And so this is the second in a series, and we are really, really so thrilled because this is a great, great people in a new sector of the world and economy. While it's a small group that's here, we are recording it. And so this is going to be part of I think, a very valuable series, not only for this community, but for a broader community. So Michael Fertik is an amazing human being. He has imagination and vision that led him to create a remarkable organization, Reputation.com, that actually tackles the issues of people's reputations online. And in this effort, dealing with internet privacy, reputation management, he is really the pioneer, cutting edge, and has identified issues and also ways to deal with them way before many other people even woke up to understand that their lives were being changed by the internet. Reputation.com actually was launched initially to protect internet privacy, manage reputations, give individuals control over their digital lives. Initially in Louisville, Kentucky. It's now in Silicon Valley. It's been remarkably successful in securing investment, and it is changing, I think, the ability of people to actually have some control. And Michael's own interest in this was partly spurred by his own recognition of cyberbullying. And the issues, therefore, are ones that cut across age groups and other kinds of communities. Michael also has been very active in national media and indeed international communities talking about these kinds of issues. He's been on Dr. Phil, he's been on Fox News, Good Morning America, BBC World News. He's a member of the World Economic Forum, and he also is very engaged in some nonprofit activities, and he will be able to talk about them as well. His lawyer, Chris Sundermeier, is the chief privacy officer as well as general counsel, and came to this work after already being a litigation partner at Cooley, where he focused on commercial contracts and other matters. He also, in addition to his law degree, has advanced graduate work in philosophy, which I'm sure he needs every single day in this work, and especially in dealing with Michael. And what I hope you'll do is talk together about the issues where you actually have had to make some judgment calls, and where there have been some maybe even tension between what the law says and what the business wants to do. So thank you so very, very much for being here.
Thank you.
Oh, and Chris Bavitz, our very own Chris Bavitz, clinical professor and director of our cyber security, cyber law, cyber everything clinic. Chris will be the master of ceremonies.
And my goal is to stay as out of the way as possible and basically turn it over to these guys, and we'll just be sure to save some room at the end for questions, so please save those up, and I'll turn it over to Michael.
Thank you, Dean Minow. Thank you, Chris. Thanks all of you. Thanks, Chris Sundermeier. So first, a couple of minutes or 30 seconds on what Reputation.com does, just to set the stage. So you may know I graduated this law school in 2005. So hopefully we can talk about sort of what entrepreneurship would look like after the law school as well. Reputation.com protects privacy and reputation. We have about 180, 190 employees, mostly in Redwood City, California, about 15 in the UK, a couple in New York, and a few scattered around. We have customers in over 100 countries. The things that we do fall into one of just a couple of buckets. The first bucket is we help people and companies protect their reputation, their good name on the internet. That usually means something like the search engines. So if someone's attacking you on the search engines and may have a legitimate or not legitimate grievance, we would help you sort of make sure that your reputation is still pristine. The second thing that we do, and that of course implicates all kinds of issues of speech, freedom of speech, of reputation versus speech, libel versus speech, your right to speak versus the other person's right to speak about you. Very important issues of law that it implicates. The Communications Decency Act, Section 230, about which I wrote a book a few years ago. Very important topics. Second major bucket has to do with online reviews for companies. So we help real companies collect real reviews from real customers about themselves. And what that does is it tends to increase the volume of reviews. And as you increase the volume of reviews, it tends to give you more of a better review mixture. And of course, there's a question about where you get to publish those reviews and where you get to give people an analysis of their review ecosystem, how they look compared to their competitors. How do you understand that? It implicates issues of copyright and other issues that are very interesting. And then on the topic of privacy, where we are walking away the largest company in the world to help protect your personal data online, and your data are being used and collected without your knowledge or permission by people you cannot identify for purposes you can never know, and they're being published in databases. And there's a whole discussion in America especially about whether those pieces of information, your address information, your health information, your purchase information, are effectively matters of public record and can be consolidated and published in online databases, or whether that's not really a meaningful use of the concept of a public record any longer. There's a different attitude here in the US legally from the one that's emerging in Europe and one that emerges elsewhere in the world, Japan, Brazil, and so forth. So very much on the cusp of these issues on privacy and digital privacy as well. So those are the things we do. Chris, do you want to add?
Yeah, I'd say the main thing for the review products, because reviews are part of it, but it's also social media. It's your whole online presence. And
Yes.
so the company now has evolved from what has historically been sort of an SEO, a privacy company, to one that really we're selling to major corporations and that are buying our products to figure out ways to efficiently manage their entire online presence, from social media to reviews to how to make their message heard in a way that resonates with the technological society today.
So we've had a lot of different things, right? So we've had a class action lawsuit. We've had individual employee lawsuits. We've had breach, which we'll talk about. We're a privacy company, and we got breached, right? And that was not fun. That was not a fun day. So part of the mission, I think, is to talk about how we collaborate and how we collaborate sometimes in moments of stress, right? Because often when you're talking with your GC, unfortunately, you're often talking about or in the context of stress, right? So first, some day-to-day mechanics. Chris is one of a 5-person senior executive team at the company, and I'm one of the others. And so I visit, we have about 150, 160 people on our main office in Redwood City. I'm there probably half the time, or maybe 65% of the time in the office. When we're in the office, I probably visit with Chris 3 times a day, I would say, right? Sort of checking in on things, going to his office and so forth. So it's a very close collaboration. We talk once or twice a day. I have to confess to you, when I'm on the road and I get a phone call from Chris, of course, he calls me from his cell phone, so I know it's him calling. My heart always drops when he calls me. It's not fun to get a call from your general counsel, because usually you're worried that something's gone wrong and he's telling you about something wrong. But normally in our day, it's usually not the case, but I just get nervous every time he calls me. So we collaborate very closely. When it comes to things like business discussions, he's in every major business discussion. How many business operations meetings do you go to?
I go to probably 5 or 6 a week.
5 or 6 a week. And so what do you do? And what do you do in those meetings?
Well, so let me just give you a step back, give you a little
Yeah.
perspective of who I am, how I came to this company, because I think it bears on this. I came out of law school not thinking about being business, but I wanted to be a trial lawyer. So I got into a small trial law firm in San Francisco and spent my first few years right out of law school trying to go to court as much as I could. I then moved to a larger Silicon Valley firm, became a partner there at the Cooley law firm, and it's really focused on trying to help companies from the outside, but mostly in the litigation context. But over the years, I sort of slowly realized, hey, this business stuff is really fascinating. So my practice shift stayed a very general litigation practice, but focused on helping companies solve their problems from the outside. So when I made the move to go inside, I'd already spent a lot of time trying to help companies solve problems, but the inside's very different. It's completely different than outside counsel. Outside counsel, you have limited information. Your job, you're being paid big dollars to make the right decision, to to go to the nth degree to find, what the legal precedent is, and then to give someone else information that they can use to make a judgment. And then they come back to you, and they want you to make the judgment for them, but ultimately it's got to be their judgment. Completely different in-house. You're making the judgments every day, all the time, from little judgments to big judgments, day in and day out. And it's got to be a collaborative process with your management team, because what your job as an in-house lawyer is to constantly assess risk. And it's always about risk. It's very, very rarely is it black or white. Is it yes, we can do this, no, we can't do this. Most of the questions that are black and white get dealt with very easily. They don't really rise to your level. It's only when it's in the gray area that you're contacted. And then you really are making decisions about the future of the company, what level of risk is satisfactory, what level of risk is not satisfactory. And that's not a decision that I can make myself, so I'm constantly in conversation with Michael about what level of risk can we tolerate in these areas. Because particularly in the business that we're in, it is just ripe with risk. Because your typical bricks and mortar business, there's a lot of established history, there's a lot of established law, precedent is built up around contracts and IP, et cetera. When you move into the internet and when you move into the sorts of things we do, nothing fits right. Even copyright rights, trademarks, patents, they're all being impacted right now. They're all the jurisprudence is changing around those issues because of the way the internet impacts it. Privacy, free speech, contracts, everything is different in the internet world. So what we spend a lot of our time doing is assessing where is the boundary that we can move up to if we need to, and not cross, or where is the boundary so that we can make sure that we don't cross it. And so it's you talking, I remember back in the days of law school, which goes back a shockingly long time now, you wanted to do cutting edge work. Well, that's the kind of stuff that you as an in-house counsel in a company like Reputation.com, you do all the time, because really what cutting edge means is that there is no clear picture. You're in the murky area, and we are there a lot. And a lot of times it's to try to set policy. Michael has done an amazing job over the last 10 years almost now in taking an area which had no thought about it and developing it into an area where the world now is talking constantly about online privacy, constantly about data, constantly about reputation, and about the way the what's published on the internet impacts people, from businesses to children to teenagers posting on the internet to law students to college. It's all out there now, but it was Michael's vision years ago that began the dialogue to help clarify these things. So we're still muddling along, and
Yes.
we're in the murk all the time.
That's important. So for example, in a technology company like ours, one of the things that engineers do and product people do is they have a stand-up. A stand-up is exactly what it sounds like. It's a standing meeting. Usually happens about once a day. Sometimes it'll happen once a week. And we do it all around our company. And the reason we do it is, how's the project going? How's the product rollout doing? How's the engineering doing? And occasionally we'll do it in front of some large sort of drop-down screens and project a new demo of a new product or a new feature on it. And I'll often go to them, not always, I can't always. But I saw, I got pulled into one, which was great, about a new release of one of the apps that we have on phones. And it was very interesting with some new features. It was about 2 weeks ago, I'd say. And very compelling, but I immediately saw that there was risk for us. I can't describe what it is, but I immediately saw there was risk for us because one of our sort of third parties might take offense to how we're doing some things with that app, and that offense might be expressed legally. So I went from that stand-up to Chris's office. But you're not your typical behavior. You don't normally go to your lawyer's office after you see a product or a new feature. But I realized that this was a potentially outsized risk, God forbid. And having seen that for myself, I wanted to satisfy myself that Chris could also look at it and say, hey, give us the green light. So I went to Chris's office and said, hey, look, just take a look. And then what happened after that?
Well, so I met with the product team and had them walk me through sort of page by page the whole way that the product worked, trying to assess whether it did some analysis of the terms of service and the platform that we were on. This was being launched on the Apple Store, and it's a free app that interacts with one of our enterprise products. But I ended up doing just a sort of detailed review of the entire product. Did some review of the language that goes around it, and came back, felt comfortable with what we were doing, and let Michael know. But again, here's the problem. As soon as as soon as the technical team sees you coming through, they're like, okay, what's wrong? What did we do wrong? So that's a little bit of your life as the general counsel. But they're used to seeing me because I sit in on a lot of the product meetings and I sit in on a lot of the business meetings. And the goal there is really, it's sort of like a perpetual law school exam. I mean, you're issue spotting. You're just looking at what's being done. Where do I need to dig in further? What issues come to mind as potential legal issues that we need to talk about? And you need to do that sort of constantly, and you need to do it early in the process, because it's very difficult to come in late when a product is far down the road and say, hey, we shouldn't be doing it this way, we should be doing it some other way. So you spend all your day issue spotting, and then I tend to elevate those issues to other members of the management team, including Michael, saying, okay, should we be doing this or should we not be doing this?
And here's the cadence. The cadence looks like this. Hey, Chris, we want to do this. And he says, well, that is clearly in the red. And he says, well, over here is clearly in the green. So the cadence looks like this. This is clearly in the red, yes? Is that clearly in the red? Yes. Is that clearly in the red? No. It's sort of dark pink. Okay? How dark into the pink and how light into the pink can we tolerate going as a company? And the question that we have to ask ourselves is, how much value can we create from this proposition versus how much risk does it create for us? Very, very tactical kind of stuff. Some of the stuff that we've dealt with, right? We had a breach about a year ago. Was it about a year ago? So it's public record that we had a breach, and the breach came through something that was an opportunity for the intruder, who seems to have been rather sophisticated, to get through. And we figured out that there was a breach within kind of a short amount of time, and then we sealed off the breach. But in the digital world, a short amount of time can cause a lot of damage when it comes to breaches, right? They transport data or infiltrate you digitally, which is, electrons. So it was actually, frightening for a while. Now, when we finally looked at all the dust and the dust settled, the nature of the breach was actually very minor. And it was very minor both as to the amount of information that was collected per person, right, per user, very, very small, and also as to the legal requirement for us to disclose. In fact, the scope of the breach was so small that only under the laws of one state in the United States were we obligated to tell the users from that state. Every other state that we had to do, what, a 46-state analysis, something like that? Every other state, both in terms of our inside analysis and the outside analysis, by the rules of every other state, we are actually not obligated to disclose. So that was the immediate question was, do we tell just the people in the state, or do we tell everybody? And
so that's the legal assessment.
the legal
Next you jump to the business assessment,
Go ahead.
which is, what do you do? We're a privacy company. We don't have to let people know. We are a reputation company and a privacy company. This will be a hit to, or potentially could be a hit to our reputation.
Our promise is we protect your data.
Right,
right?
so-
We got breached,
so
right?
do
That's our
you-
promise.
Do you disclose or not disclose?
Right.
Given that you're not required to disclose. Well, there was some dissension at the management level. Actually, Michael and I were on the same page on this one. But there were other folks that thought, hey, if we're not obligated to do it, let's not take the commercial risk of doing this.
Right.
But we ultimately made the decision to notify and do a press release and
Notify everyone.
yeah.
That's important. We notified every customer.
So you end up making these, again, another kind of a risk assessment where you're working closely together. In fact, the risk, our engineers discovered this potential breach while we were at a company kickoff party.
We were at the off-site annual cocktail party for our whole company, and all of a sudden the emails are going berserk, right? It's like ding 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 ding. We think we have a problem, ding, ding, and then you hope it's a server outage. No, breach, right? It's like at the annual off-site kickoff party. That's great fun, nice cocktail party.
Yeah. So.
Can you talk a little bit about, you were talking about being an outside litigator before coming in. Was Chris Reputation.com's lawyer beforehand? How did the sort of relationship begin, and how did you decide that he was the right person to bring in to do this?
So he had been our lawyer for a couple of weeks on a matter a few years earlier, right?
Yeah, they didn't have much litigation.
Thank God. Like a
Yeah.
$10,000 matter or
Yeah,
something like
very
that. It's
small.
a very small matter. We had a former customer who's, and And Chris was like, really, this guy's suing you? I'm like, I don't know. And so he like made it go away for a few grand. So it was pretty cool. Anyway, one thing you should know as law students is very important, is that entrepreneurs think that you are basically in the same bucket as accountants and HR people, okay? So it's very hard for you guys to understand that, that most entrepreneurs, Silicon Valley people, think that you are a tax they have to pay, you're unimportant, you may be smart, but they hate talking to you and you're toxic, okay? That's the thing you have to overcome. And by the way, there's no getting around it. It's exactly what they think about you, all right? So
He's right.
yeah, it's okay, it's true. And so it's like, oh, you're the guy I have to call if something goes wrong and I hate you, right? So the other thing about it is that typically when you hire general counsel, the board or whoever else has an opinion about lawyers will tell you that you have to hire a transactional attorney, a corporate attorney. So I went to law school, and half of us go into litigation, the other half of us go into corporate law, more or less. I guess those are probably the numbers, something like that. And you realize the litigators are very smart too. They know how to read a contract. They know how to issue spot and do all these things. And so it's just nonsense to me that you had to hire a corporate attorney. And Chris had a storied career as a partner for many years at Cooley, which is one of the 2 law firms of major renown in Silicon Valley. And I was reaching out for general counsel. We had gotten to the level that it was necessary to have someone ourselves. And Chris and I found each other, and it just seemed like a great fit. And he also had a passion for this topic of privacy. So he's the chief privacy officer as well. That's an important role that he plays. So that's how we found each other. Is there more color I'm forgetting?
No, other than I think, I would say that when you're in law school and you're thinking about your mission, to me, thinking about what the career was going to be, lawyers were in the courtroom. That's what they did. I didn't even really think about lawyers being in the business side of things. I knew they did that, but for me, it was growing up watching, all the legal shows, et cetera. That's what lawyers did. So, once I got out into the real world, I realized that the business side of things is absolutely fascinating, and you're confronted every day with really good, really important legal issues. But I still think one of the things that's important is when you're going out of law school, and if you want to become a general counsel, if you want to think about going in-house, it's a great way to it's a great path to go. I still think going to a law firm is a great basis for training. If you go directly in-house, it's hard to kind of get the broad, deep training that you get going to a law firm. So yeah, we found each other after me having been in a law firm for 20 years, and probably not at all the kind of general counsel a lot of people would have picked.
No.
But on the other hand, you end up with a tremendous amount of breadth of training that you don't get coming from an in-house perspective. You can almost develop bad habits being in-house, because one of the great things about working with a big law firm is you have so many smart people that are experts in the area that you learn from over a long period of time. And when you're in-house, it's you or it's your team, but it's a little more difficult to get the level of expertise that you do without paying for it. And one of my jobs all the time is to keep the outside lawyers at bay, because as I know from many years of doing it, they were very expensive.
So the 2 things that I think it's in a company like ours, which is at the cutting edge of difficult, thorny issues. Not all companies are, right? If you have a restaurant business, you're normally not at the cutting edge of difficult, thorny issues. It's often actually very useful. It can be very useful to have an experienced litigator, because litigators tend to be the ones who make new law, right? And there's kind of an experimentation and willingness to experiment. We also have, like any company of our scale, a certain amount of litigation. And I hate litigation. So I went to law school, but I just do not like the concept of being drug into, as we say in Kentucky, drug into litigation. And a lot of what Chris does is basically keep that away from me. We don't have a litigation all the time, but we usually have sort of one thing going, whether it's a former employee or something, who's asking for a bigger severance or whatnot, or a customer who's pissed off and saying, I want my money back, and we usually say we'll give it their money back, but may have hired a lawyer already, so all of a sudden now it's got to get escalated to Chris. I'll say, we had a class action, and it's public information. We had a class action. It's also public information. We settled the class action. So the class action was around wages and overtime, basically. And Chris will stop me if I say anything out of school, but I think I won't. And there's a very important tradition and statutory regime in the United States to protect people from working overtime who are supposed to be working hourly. And that regime is now probably 80 years old across the United States. And of course, California has also a different set of laws that are also strong. And the wages and overtime lawsuit, the class action, had to do with our people who are on the phone inside our company. So inside sales or salespeople or in some cases sort of account managers, okay? And the law is unclear on this set of issues of how you treat certain people as to salaries versus bonuses versus earned income and so forth. And it's so fine that if you give something like north of 50% of the person's on-target earnings as a function of salary versus upside and bonuses, then you may have to classify them in a certain way. If you give less than 50%, you may classify them in a different way, and so forth and so on. And the people who are in our class action, the individuals were very senior people in the world. People who graduated Dartmouth, worked at Goldman Sachs, graduated Stanford Business School. So these are not the typical kinds of people you think of as being the kinds of people for whom the hourly wage laws and overtime wage laws were created. And so all of a sudden we were sued, and we were faced with a moment where the people who were working for us, some of them for years, the individuals were saying, well, I don't want to be treated hourly. If you treat me hourly, I don't feel like I have the same kind of standing in the company and so forth. But net, we had a very sort of complicated set of questions. And net, we were faced with a lawsuit that we thought we could win. It was X to defend the lawsuit, X to settle the lawsuit. And if we had an 80% chance of winning the lawsuit, there was a 20% chance that X was going to become 3X if in fact we lost. So we settled. It took about a year to do the process. But long story short, is my first class action. And in the class action, there was a complaint. And the complaint said bad things about the company and said bad things about me. And the complaint, of course, is intended to sound as nasty as possible. So I'm sitting there reading it, having a heart attack, saying, oh my God, who is this guy they're describing? Oh my God, he did, that's me. I did what? I supposedly did what? I said what to whom? And then, the company did what? I'm responsible for what? We did what? It was like they were describing, Voldemort. I mean, they're describing someone like completely really bad. And it just made me nervous. And, and Chris came along and said, Michael, don't worry about it. I got this. And just don't read the rest of the complaint. I got this. And more or less, through a period of, kind of gathering the facts, we demonstrated to the plaintiff's attorneys that their case was, much weaker as applied to about 2/3 of the class and maybe more than they had anticipated, and that there was some color around some of the rest. So they basically, their number came from X down to, 5 or 10% of what their original intent was, and then we settled for even less than that. So, we settled for basically our sense of cost. And so that was very interesting. But that, for me, as for someone who doesn't like litigation, especially, I had to rely on Chris to give a huge amount of cover. Is that a fair story or fair assessment?
Absolutely.
Can you amplify that?
Michael would always get trepidatious when we talk about that because, one, it was personal because all the allegations are against the company, which is a company he developed, and it's a company, and there were allegations made against him personally to some degree. And he doesn't like the notion of risk. But what I thought was interesting, and one of the instances of not tension between us, but tension between the law and sort of where we had to discuss this was, so the risk for the company was that certain classes of employees needed to be treated as hourly employees, even though these were college graduates, viewed themselves as professional, and they didn't want to be classified as hourly employees. And they don't want to punch a clock and punch in and out for lunch and do all those kind of things. And you're looking at the law saying, okay, here are individuals that there's at least a risk to the company that these people, or that this kind of thing could repeat itself if we don't reclassify these people as hourly employees. And you have hourly employees, and Michael's saying, I didn't hire these people to be hourly employees. They don't want to be hourly employees. I want to treat them as adults and as professionals and as, as the way it's done in Silicon Valley.
They can earn way much more money if they're not hourly.
Right.
So they want to work longer and earn more because they're selling stuff.
And I'm telling Michael, I get that. You need to change, to minimize this kind of risk going forward. We have our arguments, but you need to change this. And Michael and Shrey Bhatia is our president. We're adamant. We shouldn't be changing these. This is not, they don't want to be changed. And I ultimately said, you know what, we have to do this one.
Have to do it.
So this is one of the ones I won. But we ended up doing a careful analysis of all the employees in the company as a result of this. reclassifying a number of them. And you know what? The employees didn't want to be reclassified.
Right.
It was an odd situation where we're saying, look, the law requires us to treat you this way. It doesn't change your compensation. It doesn't change, how you're viewed, but we're going to treat you now, we're going to classify you as an hourly employee, which means you have to clock in, clock out, take your breaks, do the sorts of things that you don't think of a professional engineer or a professional account manager or somebody doing. But under the laws, we felt like we had to do it. So we actually had some tension around that issue.
We did.
And I had to push because Michael's view was it's not what these people want, it's not what they did. And they didn't want it, but nonetheless, we did make that change.
Stanford MBA graduate going to become an hourly employee who wants to be the CEO of a company, it just didn't make sense to me. We had to do it, we did it. In this context though, so I'm the founder of the company, I'm the CEO, and whether you're the founder or not of a business, when you get to the place where you have your own GC, there's an interesting, at least experiential dynamic, where the GC, Chris is the company's GC. He's not my lawyer, but experientially, he sometimes ends up, or I sometimes experience and end up experiencing him sometimes as looking out for me and for what is sort of my baby and my interests as well, right? So clearly, he's the company's lawyer, right? That's very clear, right? That's your fiduciary.
Yeah.
But in the proximity and the intimacy of this relationship, what's very interesting is it's that close, right? He's if there's anything going on that I'm worried about, I go to him first, right? And some of it has to do with stuff that I'm worried about myself or the company may be worried about, but I go to him first. And he understands that nuance and that complexity very, very well. I think it's a function of who he is as a person, as a function of how he orients himself around the world, but also a function of his experience level. And I think if you are able to acquit yourself that way and understand that that's part of your job as a senior person inside a company, different, by the way, from outside counsel, I imagine.
Completely different, yeah.
That intimacy forms the bedrock of a very successful, open, and collaborative relationship. And that's, that I think is do you have something to add about that, right? Because there's you're the company counsel, but there's, these things have a nuance, not intermingling, but a nuance to it, no?
No, they definitely do. I mean, when you're outside lawyer, you're always thinking, who's my client? I want to be clear with everybody on the phone here. I'm not representing them individually. I'm representing the company, et cetera. When you're in-house, things get a lot murkier because you're dealing with the people you work with every day who are coming to you for legal advice, oftentimes not even having to do with the company, Somebody, employees coming in and saying, hey, I'm getting divorced. Can you recommend a lawyer? What should I do? You get the whole range of that sort of thing.
Really?
But, yeah.
Wow. That was not me, by the way.
But you have to counsel them. Hey, I'm not your lawyer. You do this whole thing. But it's confusing because you are part of a management team. And one of my characteristics, whether it's good or bad, is I'm pretty fiercely loyal. So I will be loyal to the company, but also be loyal to Michael. And I think that as your job, particularly as an outside lawyer, you learn sometimes, hey, I didn't get the best facts, but I've got to go advocate with a passion for these facts. And you develop that kind of zealous advocacy skills. And it's the same thing within the company. My job is to protect the company. It's also to protect Michael. And that's how you end up viewing things.
So
but you do have to draw some lines sometimes.
In any given day, Chris can work on the following things: a lawsuit, as we described, an arbitration. We bought a company, and we had sort of a bad actor founder of that company who bilked the company on the way out, and then sued us. and so it's like, look, you evaded taxes and you bilked the company. so he's handling that. Contracts with customers, contract negotiation with customers, sometimes over large deals, employee and personnel issues, onboarding, offboarding, H-1B issues, immigration issues, our terms of service being rewritten, but also sometimes even a little bit more interesting or colorful things. We had a former employee who threatened to kill several employees, including me. This was not because he was displeased with his work. He just was a lunatic. And a lunatic who's making, repeated and very specific death threats, including, I'm going to hack off your head with a machete that I have, things like this, like very specific, not fun. This is a while ago. And so, he's going down to the police station to get this guy sorted out. So it's a full stack job. And, a lot of these things, a lot of the company rests on Chris's shoulders, day to day and month to month. So It's a full stack. He also deals with privacy policy, interacting with privacy regulators, interacting with people who care about privacy in the world, the United States and Europe, make sure that our regulations are going the right way. Very important for us in our business that we have a hand and a voice in that debate, that we can help shape the debate about what happens to your data and your digital DNA, even before PRISM and before Snowden, now increasingly so. So a very, very varied job, and we interact on almost all of it, I would say. At some point we talk about almost all of it.
Because you obviously have the trust and respect of Michael and the executive management team. You talked earlier about, I know jokingly, but the software developers, product developers see you coming down the hall and they say, oh geez, here comes the lawyer, he's going to make things difficult. How do you gain their trust? How do you inject yourself into the product development process and be a proactive force for good and not a force who's just going to squelch innovation? And
well, Michael's absolutely right that there is a suspicion of lawyers, and there's a suspicion of litigators, because litigators, you presumably like to fight. Why would they choose that profession? You spend your time fighting, whether it's about discovery or everything. You fight daily, So when I met with our president, Shrey Bhatia, during the interview process, and I think his biggest concern was, are you going to be a, positive force towards moving the business forward, or are you going to be the guy who holds us back because you're not collaborative, or you're going to draw too many hard lines? So I think the thing I had to convince him was no, I've been doing this for a long time, and the goal is to give practical, good advice, based on sound judgment to your clients, which is the business. And I think you can pretty quickly win people over. If you're the kind of lawyer who says, okay, this contract has to be absolutely perfect, it's 42 pages, that's not going to work at a startup. You need to be lean and mean, figure out what you need, what you don't need, what you can live without, what you can't live without, and be willing to compromise and make the changes that you need to make. And I think once people see, that, plus, the reality is what people do at the company is a whole lot more interesting and a lot more, challenging than what I do. I look at the engineers and the marketing people, and the fun thing is I get to see all the products. I get to see what they do. If a new commercial comes out, I get to hear the commercial. Make sure that there isn't something said in there that shouldn't be said. If there's new marketing, I get to see it. So I'm seeing what everybody's doing, and what the fact is that a lot of them are pretty talented and interesting people, and so I think they pretty quickly realize I'm not there to interfere with their work, but just to make sure that it goes forward in the right way.
There's a commercial choreography as well. There's a commercial choreography that's important. So you may intuit this already and know this intellectually, but practically it's very important. So sometimes there's a contract with a large customer. Let's say it's a $500,000 contract, which for a company our size, or probably any size, is an important contract with an important customer. And normally if it's a $500,000 that's being spent by the customer, normally there are multiple people on the other side of the table who have to sign off on it, whether it's the business person, the sponsoring business person, maybe their boss or their boss's boss, maybe something called purchasing, maybe legal, and so forth and so on. On our side, it's like you're looking at it, right? It's like Chris and me and Shrey and like the salesperson. So it's a very, very tight team over here, and they have multiple departments around multiple thousands of people. Okay. So sometimes, Shrey, our company president, or the salesperson, will take on a certain job, and they will communicate very clearly. I'm going to play good cop or bad cop, or I'm going to focus on this one issue, and you raise 3 issues, so we get them tied up on this issue, and really all we care about is this one issue, right? So there's kind of choreography. It's very sensible, very typical, but that's a very closely choreographed event. Also sometimes it's like, hey, we didn't get exactly what we want. Why don't we take our draft and now just send it to legal, and then you move it on, right? And so there's a kind of a moment, and sometimes look, these guys have a lot more leverage than we do, and we have to give. And then can we just give ourselves a little bit of protection? And then Chris talks to the lawyer. The lawyer normally understands that we have legal issues or concerns or risk mitigations we have to make, and so he takes it on as the business voice for the company. So that choreography is very critically important. One other thing, Chris, that I think another Chris may have picked up is when part of Chris's question, when the executives talk to you, there's a question about, is this person going to help us or get in our way? But when non-executives talk to you, or you walk in that room, sometimes people feel they're in trouble.
It's a little bit like the principal coming down.
Right.
Sometimes.
So how do you handle that, right?
Well, I think people get to know your personality
Yes.
as well. So
Yes.
I'm pretty non-threatening to most people.
Yeah.
Doesn't mean that if I send someone an email and say, hey, could you stop by my office? They're thinking, oh God, what did I do? But there is some aspect of that. But I think that's fairly typical. But I think you develop your own relationship with most of the team because you're interacting every day. You're in meetings with people. The new employees know you because I also handle the stock and the stock options. That's all under my purview. HR, until very recently, we hired a chief people officer. was under my purview. So you know everybody in multiple capacities, and I think it works that way.
And look, by the way, everybody in the company wants the general counsel to be like that. We want the general counsel, but to be Dudley Do right? And who you don't want the general counsel, but to be the slickest guy in the room, right? Then you kind of feel weird, right? Business people, entrepreneurs, non-entrepreneurs, revenue generators, engineers, we're the ones who are supposed to say, hey, let's go over there. And the general counsel is supposed to say, hey, maybe not, right? Maybe not. And we all want the GC to do that. You don't want a GC who's going to do it too much, because then that GC becomes the party of no. But if the GC is the party of permission slips, then the company can actually get itself off the rails. So, and by the way, you have no friends in that role inside the company. There's no one else who's saying, maybe the CEO in some cases will say, hey, let's do it this way. But usually you are by yourself, making sure that the guardrails of doing it lawfully or something like that are the right ones. And so it can be a solitary job. Much like my job, it can be a solitary job. And so you should know that it's not, you're not part of the revenue team, right? You can create yourself and make yourself an assistant and a support and a catalyst for revenue, but you're not part of the revenue team. The revenue team tends to gang up and say, let's do more revenue. And you might have to say occasionally, yes, that's right, we need to do that, but there are a couple of things we shouldn't do to get that revenue. Because if we do that contract without an indemnification, that could put the company at existential risk, God forbid, right? And that's the kind of line you have to draw.
Yeah, and the worst thing is getting between a sales guy and his commission too. So
Which
when you start negotiating a contract saying we need these protections, the guy whose monthly paycheck is on the line does not understand. So you have to walk a delicate dance there too.
I want to make sure we save lots of time for questions. Anyone want to start? I'm happy to ask a couple more, but any from the room? I wanted to dwell a little bit more on something Michael raised out of the box, which was the litigation versus transactional distinction. It's something that students ask a lot, I think, and hearing the breadth of issues that you deal with when you're the general counsel of a company like this, whether it's IP privacy, employment, that sort of thing. Do you think that having been a general commercial litigator, where you were probably, I assume, litigated all those kinds of cases, and you had to become an expert on the spot in any of those kinds of cases, do you think that kind of helps you?
I absolutely think so. Yeah. I mean, I think it's an atypical path. Yeah. But when I decided, at some point a few years ago, that I was going to make the change into an in-house lawyer, I thought I was perfectly poised. I mean, my career had been complex commercial contracts. I had done securities litigation, fiduciary duty litigation. I was part of our venture capital litigation team, so that basically I helped advise boards of directors, which are usually comprised in Silicon Valley of venture capitalists who are in conflicted positions, owing fiduciary duties to their company that they're a board of, as well as owing fiduciary duties to their partners, as well as owing fiduciary duties to their limited partners in their funds, and they get themselves in all kinds of trouble, as subject to a lot of lawsuits. I'd done IP, trademark, and various types of M&A transactions that have gone awry, usually around, again, a lot of times fiduciary duties were securities related, but felt like I'd seen all these issues from the other side. It was someone else had done the deal. I'd seen all the documentations and how they could go wrong. So for what a GC does, which is really, if I need deep expertise, I frequently just have to go outside the company to find that. But if I'm issue spotting, I felt like I'd spent my career doing that for companies. Particularly toward the latter years when you got a little more senior, you're getting companies up saying, hey, we've got a mess. How do we muddle our way through this? Particularly companies that didn't have in-house GCs. But, if you're actually deciding to make that career change, everybody will tell you litigation is a great thing, but you should leave that early. I think if you're thinking about an in-house position, most people will tell you, sort of the recruiters that are out there, they'll say, go be in a law firm, have an emerging companies or some specific corporate-related practice, maybe litigation, but then leave after like 5 or 6 years and then go in-house and then have that career in-house. And so leaving later to go in-house, the wisdom is, and I'm not sure it's wisdom, I think it's just sort of the difference is, hire someone who's an experienced corporate lawyer as opposed to a litigator. I think it's a mistake, but worked out well for me.
I think it's a mistake too. Normally GCs are imagined to do M&A and deals and so forth. And a lot of what we do does involve deals. We bought about half a dozen, maybe 8 companies, and we've been in process to buy a few others that didn't work out. And Chris has led the charge in all of those. One that was a little more complex, he involved outside counsel, but basically he's been doing most of them, I think, largely by himself, right?
Right.
And so one was overseas. We had an overseas advisor as well. But these are things that smart, capable people who can handle complicated things, as any senior lawyer will do, can do. This is not something that a corporate attorney only can do. And also, if you have a company or an outfit with interesting, novel legal issues, having a litigation background is very powerful, I think. But rarely will you encounter a CEO who's actually gone to law school. Unfortunately, that's increasingly rare.
I actually find that really useful.
Yeah.
Because when I'm talking to Michael, I can count on his understanding of the law in a way that I can't count on with the other executives. Even when you're just explaining something like what's the difference between mediation and arbitration, or I can speak in a shorthand to Michael that I can't to the rest of the executive team, which is a huge advantage for me because he gets it, he knows it, he understands the risks, understands the concepts in a way that the rest of the team, who are very seasoned, experienced people, who I've known, some of them for years, just don't get it in that way. So, if you have a desire to be a CEO, it's great training for that too.
It is. It is good training.
What about managing outside counsel and the costs that go along with that? I was a former in-house lawyer, and one of the things that I had to do a lot was explain to our CFO why we had very large legal bills all the time for certain matters. What's
interesting is our current CFO was a client of mine, and he was at a small company where the founder of the company had left by the time Mark, who is our CFO, joined. But the founder of the company is now doing 20 years to life in federal prison. But it was only after about 5 years of selling company securities in a whole variety of fraud schemes, which I represent the company in a whole series of litigations. So Mark was used to seeing massive bills from me for years.
Right.
So he's not at all alarmed by the little bills I bring into him now.
That's great.
But no, it's a big thing because outside counsel is extremely expensive. When you're a company, and I don't think I realized this to the full degree when I was outside counsel, but one of the reasons why I wanted to leave being outside counsel is I just found the level of billing to be just completely out of whack with what's reality. I mean, my rate when I left was $800 an hour, and I wasn't even one of the more expensive lawyers in our firm. And it's just this, mid-level associates and junior associates that are $400 or $500 an hour. You can just rack up an amazing level of fees with very little substance to a case. And as an outside lawyer, you don't have the judgment to say, I'm just not going to do that. And if I'm handling internally, I could say, I'm not doing that. I made the judgment that I'm not going to handle that. I'll live with the exposure for that. As outside counsel, you do everything to the nth degree, so your bills just go crazy. And so it helps having been outside counsel because I can say to them, look, do these things, don't do these things, and I can give them specific instructions. But it is a big process, and if you're not on it all the time, the bills get out of control fast.
Yeah. Is there a question over here?
Here. Yeah, I have a question. How does the fact that you went to law school change the way that the two of you as a team interact with business counterparts rather than outside counsel?
How does the fact that we went to law school change the way we interact with other business counterparties?
For you, is it different that you are a graduate of a law school rather than a CEO who is not a graduate of a law school, or are you so steeped in doing the business side of things that you have a similar dynamic?
Being a law school graduate can be a detriment if you're a business person, because law school trains you to be careful. Law school trains you to think things through a lot. And both things can be problematic if you do them too much, especially if you're an entrepreneur, not just a business person. Incrementalism is how the law works. There's also kind of something very dumb about Anglo-American law. The basic context, the basic concept of Anglo-American law in litigation is that you find out the truth through oppositional fighting, right? It's like I say this is true and you say you're a f***ing liar, and then somehow we're supposed to find out the truth between these two ridiculously antagonistic poles, right? And imagine any other relationship in your life working like that. Imagine like getting along with your boyfriend or girlfriend or husband or wife like that. It's like every time you talk, it's like, this is true. No, you're a liar, and it's like that doesn't, like, that's how the law works all the time. That's the basic concept of Anglo-American law, which could not be dumber, right? And 400 years ago, in the halls of the Inns of Court in London, that might have sounded brilliant and arcane, and we are still just pregnant with that deep flaw of truth finding and truth telling in law. So you have to kind of lean against those things. On the other hand, I guess if you're a reasoned person, if you know tricks of and moves, intellectual moves of how to get around certain issues and how to diffuse certain issues and how to emphasize certain issues, or if you can lead someone down a path logically, that can help you a lot. If you can also identify sources of enormous pools of risk and then act accordingly, that can help you. That would be my answer.
In the middle here, yeah, here.
So my question is for Michael, and it's at what point in your life as a student or in your career did you realize that you wanted to go into business as opposed to the law, and did you always have an entrepreneurial spirit, or was it with the idea of Reputation.com that you realized that was your kind of business segment?
That's a great question. I started my first company when I was in college here at 19, as a junior in college. As an internet company, I sold it. Then I went to law school, and so law school was the one that took me off the path. So I'm Jewish, right? I come from like a liberal pinko Jewish family in the Upper West Side of New York, and so I had this very romantic Jewish Talmudic idea about what law school was going to be like, and boy, was that wrong. You know what I mean? Like we were going to talk about the Constitution all day. Like law school is it's like a plumbing school. It's like a professional school where you learn like something called contracts. For some reason, we still have a semester of contracts, and we still have a semester of torts, as if you couldn't learn it in like 3 weeks, right? We still do it this way. So I was very deeply disappointed about what law school was going to be like, what law school was for the first year. And then in my second and third year, I rediscovered and found things that I loved. I ended up studying critical legal theory, which is something that the Duncan and David Kennedys here and some others teach. And I ended up doing those types of things instead of law classes, like corporate law I didn't do, tax law, securities law I didn't do, all those kinds of things. I haven't taken the bar yet, as my Jewish mom still reminds me I should take the bar at some point. So I actually came into law school having been an entrepreneur, expecting, by the way, to go to a law firm. I worked for Gibson Dunn in DC for a summer. I clerked for a federal judge after graduation, and then I thought I was going to go to a law firm, but I ended up going to start another company that occurred to me when I was clerking. So that doesn't mean that that if you don't have an entrepreneurial experience or a business experience coming to law school, you shouldn't graduate with one. I think part of my mission coming to the law school as an EIR in this session, I'll be teaching a class next spring in 15 on digital privacy. Part of my mission here is to point to a different path, right? When I was in law school, basically there were a few paths. Being a Supreme Court clerk was like the really awesome one. And then you become a professor. For some reason you perpetuate this thing, and that's like super duper awesome. Like that's the most awesome you can possibly be, is be a professor at the law school you graduated from 3 years after you graduate. Like that's the best thing you could possibly be when you're in law school. The second best thing is like something like save the whales or defend the indigent, right? And the third best thing is like prosecuting, and then what everybody else does is go to corporate law. Like there were like 4 paths, right? And the people who showed up to law school were like one of those 4 people, right? And so, like I think all of those things are actually essential and important. But my mission is to explain why we should be the Harvard Leadership School the way that the Harvard Business School. Can you imagine the Harvard Business School describes itself as the Harvard Leadership School? What a scary thought, right? Why shouldn't the Harvard Law School be the Harvard Leadership School? So my mission here is to point to a different path where people who with a remarkable set of skills, whether through the path of law or through the path of business, can become leaders in whatever fields they want to be. And so that is expressly my mission. So though I was an entrepreneur beforehand, it is very easy to discover that in law school and then pursue that. And there's so many people who want to hire you. There's so many people who want to give you money. There's so many people who want to give you jobs that are not legal jobs. But the law school does a very excellent job, of which it should do, of teeing up the jobs that are available and for which the market's very hungry for supply like your talent. It was very high caliber talent someone has to feed the beast of the law firms and of the prosecution offices and of the save the whales and defend the indigent. Somebody has to do all those things. And who better than Harvard Law students? But I would love to point to an additional path that we can consider.
Question here?
So both of you guys have some type of legal background, and Reputation.com, the product is it's related to legal issues, like freedom of speech, like you mentioned. Does that mean there's a particularly antagonistic relationship between you guys and your CTO or VP of research, the person who's trying to develop the next groundbreaking technology within your guys'?
That's a great question. What do you think?
I think the answer is no. I think
Yeah, I don't think so.
we have a very collaborative relationship,
Yeah.
and the reason why is because it's a scary world out there for these engineers. Because, it's very unknown what you can do and what you can't do on the internet right now. I mean, there's issues about scraping. There's issues about copyright. There's issues about privacy right now and security, and the engineers, they want to create. Our VP of research is, insane. He graduated college at 12 or something. I mean, he's a super smart guy, worlds beyond me. But we talk every day. One, he's the guy who I go to for I do all the patent stuff, and we've got a dozen patents in the last year, and we've got about 30 more filed. But he's got all the great ideas, and he's super smart. But he also knows that there are things he can't do, and that he needs to know where he can go and where he can't go with his products. So it tends to be pretty collaborative, particularly if you catch it at the early stage.
There's been an arc. So when we started the company, privacy was not on most people's radars. Now privacy is on everyone's radar. And so at first, recruiting engineers, you had to kind of filter for, do they think that privacy is something that's bad? And now most engineers are like, privacy is something that's good. So now we're on the right side of that curve. But 6, 7 years ago, privacy sounded bad to some engineers, as well as some lawyers, by the way. Now it sounds good to most people. So it's a different advantage.
Sorry,
Oh, no, yeah,
follow-up. So have you noticed a really big shift in Silicon Valley among the engineers in terms of their thoughts on net neutrality and just how the internet should be?
Has there been a shift in Silicon Valley attitude on these issues? I think that among engineers, typically on topics like net neutrality, they either had no opinion or they were always supportive of net neutrality, unless they worked at some of the companies that had no interest in that. But the cutting edge Silicon Valley people usually were supportive of net neutrality. There's still a mix of issues on patents, whether they believe in software patents and so forth. But privacy definitely is now for the cool kids. Liberation technology is for the cool kids. So we are now a cool kid company, whereas 7 years ago it may not have been true.
Yeah, Chris, this might be more directed towards you. So at the beginning, when you have to make a leap into the darkness because policy or regulations aren't defined yet, do you guys just make that leap and then hope to change it later on? Or how does it work? Because, there could be a red zone, but sometimes there's no light at all. You don't know.
Yeah, there is. We make those decisions every day, to be honest. Not every day, but once a week we're making a decision like that. It's with a new product. Can we do this or can we not do this? And it's not clear what the law. You're also, some of these new laws, particularly around privacy and security, they're made for big companies. As a small company, you cannot do the things to the nth degree that people at Google can do or people at Facebook can do. They don't do them at Google and Facebook. In fact, they're the worst offenders, but they at least have the money to do the kinds of things that you would need to do certain things well. So you have to sort of say, okay, here's what the best, most safe, conservative position would be. How close to that can we get in terms of a lot of issues, just based on cost and the practical reality of we're trying to make a profit and we're trying to do business. We're trying to be a company that wears a white hat, not a sketchy company. So we're trying to lean a certain way. How far can you go? You're always making a judgment. Will this get us enough? And half the time, what the question that's being asked me is, is this acceptable? Is this enough? And then you're making judgments that, yeah, I think that's enough. But you do that with everything you do, whether it's contracts. Okay, what can we live with? What can we take out? How much risk can we accept here and how much not? Is it Ford on the other side, or is it the little guy? If it's Ford, I'm going to do what Ford tells me. If it's not, I'm going to do this. So you're making that judgment. But it is a matter of hoping that the law evolves in the right way in areas where you think that you're on solid ground or that it's vague, but you think the law is moving in that direction. If you're out in front. Otherwise, you may just pull back to where you think it's safe, although a lot of our decisions are, let's push out in that area. But then you have to assess, okay, what happens if I'm wrong? How much financial exposure is there? How much legal exposure is there? How much reputational harm is there? Because obviously, our reputation is a big deal to us. So we have to sort of assess that and then make a call. And then it's usually Michael, Shrey, and a couple other folks making that call.
Then you eat your vitamins and say your prayers and hope that it works out.
Exactly. Yeah.
That's a good note on which to wrap this up, I think. Let's join me in thanking Chris and Michael for
Thank you,
coming.
guys.
And thank you.